All rise. The First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have one case on the docket this morning, 701 Palafox LLC, Green Hut Construction Company, and Green Hut Construction and Development LLC versus Scuba Shack Incorporated, a Florida corporation. Counsel, if you're ready, you may proceed.
Good morning, Your Honors, and may it please the Court. Samuel Spinner on behalf of the appellants in this case, 701 Palafox and the Green Hut entities. If I can please reserve 5 minutes of my time for rebuttal.
So noted.
Thank you, Madam Chief Judge. Appellants respectfully request that this court reverse the trial court's non-final order granting Scuba Shack's motion for leave to amend to assert a claim for punitive damages because the motion, accompanying complaint, and evidence was insufficient both substantively and procedurally to support that claim. As Your Honors know, the Florida appellate rules were only recently amended to authorize this type of non-final direct appeal challenging the merits of the trial court's ruling on punitive damages. We're no longer stuck with filing a petition for cert and arguing that the trial court departed from the law's essential procedural requirements. We can now challenge these orders head on, if you will. And I submit that the Florida Supreme Court, in amending that rule, had a case like this in mind because the evidence in this case, the allegations, and the proposed complaint simply do not support a reasonable evidentiary basis for the recovery of punitive damages as a matter of law. We've raised several arguments in our brief on both substance and procedure. Just briefly on the procedure, it's clear that Scuba Shack did cite the wrong standard in its motion to amend, although the trial court ultimately cited the correct subsection of the rule in its order, and Scuba Shack also did not address the corporate liability prong for punitive damages. But setting those aside for a moment, Your Honors, the trial court was wrong on the merits because the allegations proffer evidence and complaint were simply insufficient in this case to establish punitive damages. Punitive damages are not available in routine negligence claims. The case law uses terms like violent, oppressive, malicious, with reckless disregard to others' rights, bordering on an intentional reprehensible act, or involving an element of outrage similar to that found in a crime.
Right, and we, and I think we have the statutory definition of gross negligence in front of us, which is the theory that the plaintiff was proceeding under, correct? Right, so when we look at what was actually proffered by the plaintiff appellee here, it seems to consist of the report of Mr. Jacobs, and I think, let me go through some key portions of that and talk to you about how that, might inform our analysis here. So, on page 4 of the report, Mr. Jacobs recommended with regard to compaction of the site against large vibratory compaction equipment for compaction of the existing subgrade.
Correct.
All right. And I think that the theory that we're hearing, at least on appeal, is that the recommendation that there not be vibration in and of itself is a suggestion that there should not be vibration used in any component of the construction, not just for the compaction. So could you address that kind of theory? It really wasn't fleshed out in the motion for leave to amend or the amended complaint, but it seems to be evolving a bit. So why wasn't it a sufficient basis for the trial court to find gross negligence?
Certainly, Madam Chief Judge. So I think what you've seen in the briefs is that there's been a little bit of a backtrack or departure from what was alleged in the motion to amend. When we had the motion to amend, it was very specific. Mr. Jacobs said, don't use large vibratory compaction equipment, and as you noted, that was in reference to compacting the subgrade. And when it came out that we didn't use that type of equipment, what they're talking about is essentially a vibratory roller. If you look at a highway construction project, it has the big drum in the front and it rolls and it compacts
Sure.
land. So
Let me just interject this and ask a question. So the actual motion for leave to amend in paragraph 6 talks about, despite the clear warnings and recommendations in the report, the defendants chose to employ large vibratory compaction equipment in reckless disregard of the report's findings. Is there any evidence or even a proffer available to show that the defendants used large vibratory compaction equipment?
No, Your Honor, and that was a theme of our initial brief, and especially in our reply brief, once we saw essentially a little bit of a backtrack on what was alleged. But I think the bigger picture, Your Honors, is that we're talking about alleged accidental property damage. We're not talking about intentional property damage. We're not talking about deliberate violence or oppression like the statute talks about. And I think it's important to keep in mind that installing sheet piles, regardless of how it's done, is not in and of itself negligence. The only reason that installing sheet piles in this case is alleged to be negligent is because of the potential for buried debris in the soil. And so it's not like installing sheet piles in a vacuum is something that we can look at and say, wow, that was really egregious conduct. It's only rose to the level of simple negligence in this case we submit because of the potential for buried debris.
All right, so you concede a simple negligence claim is available as to the installation of the sheet piles, correct?
If plaintiff can meet their burden to prove at trial that it was reasonably foreseeable that installing sheet piles would cause damage and can prove that damage actually occurred, then certainly that's their burden.
And did Mr. Jacobs ever address sheet piles as opposed to foundation piles in his report?
He did not, Your Honor, and it's important to recognize the difference. What Mr. Jacobs was saying is that you can have a large square steel column that you drive into the ground with a huge pneumatic hammer that drops from a crane. And what he said is because you shouldn't do that, what you should use is an auger that is hollow. It drills into the ground. It creates the space for what would be the pile, and then you fill it in so that you don't have to ram this huge pile through the ground. That's what he was talking about. And as you noted, Madam Chief Judge, he was not discussing sheet piles, which were done on the southern border to prevent damage to Scuba's property. And I think that's a really important point here, Your Honors, is that my clients could not have acted with reckless disregard to Scuba Shack's rights because the installation of sheet piles were specifically designed to protect Scuba's property.
Was the contractor or subcontractor who was responsible for the sheet pile installation or any of the engineers associated with that, was there any evidence presented about their conduct and whether they considered auger piles versus sheet piles and the regular piles in that installation?
No, Your Honor. The evidence was essentially consisting of Mr. Piaskowski, a retained expert, reviewing Jacob's report and leaping to the conclusion that we must have used the vibratory compaction equipment because he says damage occurred. But there was no evidence about what Coastal did, the subcontractor that installed the piles, or what was considered or why they decided to do sheet piles. And sheet piles are just different than the type of pile that you're going to install for the foundation.
Why was Mr. Piotrowski's conclusions not supportive of a claim for punitive damages?
Being Mr. Piaskowski's conclusions, Your Honor?
Yes.
So there's a few issues. One, our position is that ignoring an engineer's recommendation not to use certain equipment in and of itself doesn't support a punitive damages claim. That opens the door to simple negligence. The courthouse door for a punitive damages claim remains closed because knowledge that your actions could foreseeably cause harm to a third party is an element of a simple negligence claim. It goes to the foreseeability as it relates to legal duty and the foreseeability as it relates to proximate cause. And so only if my clients had a reason to believe that installing sheet piles would cause damage at all do we even get into the realm of simple negligence, but we're not even approaching the standard for the type of reckless indifference to rights required for punitive damages, which is what I was getting to, is that this was a precautionary measure. It would have certainly been more negligent, whatever phrase you want to use, to not take Scuba's property into account at all and just dig next to it and hope that the soil doesn't collapse. Because if you're digging next to a property, there's a...
Let me stop you there and ask you about our proper standard of review. So the trial court has to make a determination under the statute whether or not there's a reasonable showing in order to allow the claim, right?
Correct, Your Honor.
Is that conclusion, is the trial court's conclusion that there is or is not a reasonable showing, is that a factual finding or is that a legal conclusion?
It might be a mix of both because the findings of fact have to, support the elements of the statute in finding that it meets the standard. But the overall review of the trial court's order is de novo. The parties seem to agree on that. And of course, we don't have a body of case law addressing direct appeals in the standard of review because this wasn't a procedure that we could utilize until April.
Right,
of this
and
last
so
year.
that's partly why I asked the question. So to the extent that the trial court is required to make some factual conclusions about whether or not the evidence does make a reasonable showing, should we review those conclusions de novo, or do we give some deference to those conclusions?
I think it should still be reviewed de novo, Your Honor. And while we don't have a direct appeal case law, what we do have is the case law on a later appeal of a denial of a motion for punitive damages. And in those cases, both parties cited the estate of Despain versus Avante group in our briefs out of the 5th DCA, which did say that this is overall a de novo standard of review.
And by the way, how would we go about that in this case, looking at the trial court's factual findings? Because in his actual written order, he talks about the evidence reviewed and kind of laundry lists what that evidence was, establishes a reasonable showing. So we look at all of the evidence submitted as a whole. What is the task for us?
I think it is to look at the entire evidence as a whole, to look at the standard for punitive damages in conjunction with the evidence and see if they match up and we get over the hump for the plaintiff pleading a claim for punitive damages. And as you saw in their answer brief, much of the argument was dedicated to saying we don't have to prove our claim by clear and convincing evidence at this point, which we're not saying they do, but you have to make allegations and proffer evidence that show that if those allegations were proven, they would actually support a claim for punitive damages. And our position is that even if you took everything they said in their motion as true, not using equipment that an engineer recommends not to use is simple negligence. It is not the type of wanton disregard. It's not the type of reckless indifference to scuba's rights. And but for the fact that there was buried debris on this site, the installation of sheet piles is nothing more than an ordinary task on a construction site so that we can excavate without soil toppling over because it creates a wall. So now we can dig next to it and it supports the horizontal loads of the soil, whereas the auger pilings and the foundational piles support vertical loads because it has the building on top of it. And that's why we kind of pointed out that they're essentially apples and oranges in this case, and the evidence doesn't support Piaskowski's conclusion that we just disregarded using auger piles and used sheet piles. It's just an ordinary thing we do during a construction project.
What must a plaintiff show or establish to set forth a claim of vicarious liability of a corporate employer for punitive damages?
Yes, Your Honor. I am in my rebuttal time, but I'll do my best to answer your question. So for the corporate prong, I think they at a minimum have to identify the managing agent whose actions they're claiming bound the corporation, because it's clear that Scuba Shack is proceeding under a direct theory of liability, meaning that they're saying that the managing agents of these three respective companies personally committed the wrongdoing as opposed to knowingly ratifying, condoning, or consenting to the wrongdoing of another. And so in all the body of case law, it's always been the court looking to which managing agent or purported agent was identified and what did they do. But in this case, the allegations are all in vague terms referring to appellants in their corporate capacities, but they didn't say that this was the managing agent, the president or CEO or board member or similar person who performed these actions. They vaguely refer to the design team. They say that we're going to need more discovery to figure out who those people are. And our position is that they had to do that before they requested these exemplary damages. They had to identify these managing agents by name and present evidence of who they are, what they do, so that this court and the trial court could make a finding as to whether they were in a position of power such that their actions bind the company as a whole, as opposed to a mid-level employee or regional manager or someone who might be in a management position but is not a C-suite executive or someone who speaks for the corporation. And so in addition to this not being punitive conduct, we don't even get past even if it was punitive conduct, we don't have that missing element of a corporate entity knowingly ratifying or participating in the conduct. And for those reasons, this order cannot stand, and I'll reserve the remainder of my time for rebuttal.
Thank you, counsel.
Excuse me. May it please the court, Philip Pugh on behalf of Scuba Shack. Judges, I appreciate your time here today. I want to start at my comments, if I may, as to why I believe that punitive damages are appropriate in this case from a broad perspective. Now, this is a property damage case. Most of the cases you see on punitive damages are personal injury, wrongful death, and that sort of thing. Let me put it in context, if I may, a little bit. This is a part of Pensacola where you have zero lot lines, properties running from a road to a canal. They're side by side. Single-purpose entity comes in, it bears the name of the address to build a condominium right up to the zero lot line of my client's property. And in the course of doing so, they cracked the building so badly that we've had to have it raised. Okay. Now, my point is that if the damages for that are simple negligence, when the developer knew good and well that there was an extreme danger to what he was doing, then we are, in effect, condoning the behavior. And here's why I say that. I believe, and we're not into financial discovery yet, but I believe the financial discovery that we're going to be able to get into, assuming the affirmance here, will support the conclusion that I've drawn from the existing evidence, which is that this was a calculated decision.
Okay, well, let's go through that, if
Yes,
we
ma'am.
could. In the motion for leave to amend that you filed, the only kind of clear warnings and recommendations in the Jacob report that you point to in paragraph 6 is choosing to employ the large vibratory compaction equipment in reckless disregard of the report's findings. Is there any evidence or even a proffer to show that large vibratory compaction equipment was used in this case?
Judge, I need to acknowledge that I should not have used the word compaction in that motion, and I realized it after the fact. However, if you take a look at the affidavit that's attached from my engineer, Mr. Piskowski, what he says is that they had the report that told them that the soil was unstable, the soil was going to move, there was buried debris, and they chose to use a large vibratory hammer. I think he used the term large vibratory
Equipment to drive sheet pilings.
Yes,
Now,
ma'am.
the challenge I have, I think that I'm struggling with here, is that Mr. Jacobs' report doesn't refer, in fact, and he testified to this as well, never discusses sheet pilings. He is only concerned strictly with the foundation pilings. In fact, that's what the purpose of the report is, dealing with that, so he has nothing to do with the sheet pilings. All right, so how do we get from Mr. Jacobs' report to a wanton disregard of a, quote, warning against using large vibratory equipment for the sheet pilings?
So in both instances, where the rubber meets the road is the extreme shock and vibration that's caused. And what I struggled with at that time was the suggestion then that the owner knew that there was buried debris and that vibration could cause a problem, so he could not drive pilings into the building. However, he can disregard that knowledge and drive sheet piles along the boundary because that's a different thing.
Well, and let's take this to its logical conclusion. It seems that the concern here is vibration, which can cause damage to existing structures.
Yes, ma'am.
Vibration can be caused by a lot of things. It can be caused by driving a big truck with lots of concrete onto a site, right? You can see that. Right, so if the vibration from other things had come onto the property, would we then be, pointing back to the report that regards foundation piling and compaction equipment, but not the sheet piling?
I don't think so, Judge, and here's why I say that. Subsequent to the filing of the motion, we took the depositions of both the engineer who drew the report as well as the structural engineer who designed the building, Mr. Kraft. I did not proffer those because they came after I filed my motion and before the hearing. However, the owner requested the court to consider those and filed them in opposition to the motion. I was then able to cite to them. If you take a look at Mr. Kraft's deposition testimony, pages 18 through about 24, I believe it is, I actually go through this with him, and he acknowledges a number of things. He designed the building. First, he told us that he didn't design the sheet piles, knew nothing about it, didn't even know that there was damage. Once he was caught in that and saw his documents where he designed them, he came back and changed his story and told us that, yes, they knew there was buried debris everywhere. They know it's dangerous there. He actually described what they were doing as like playing roulette. He said that, we hoped we could get it slided in there, wouldn't cause a problem. It didn't work out that way. I asked him, wasn't there another alternative? No, there's no other alternative. However, the deposition reflects that once they cracked my client's building top to bottom, they went back to the drawing board and did something that was slower but didn't cause any more damage. And so what I would ask this court to consider is that in a scenario like this, where a private developer is building something, so long as he can look at the value of what he's building, if there is a sufficient differential between that and the value of the buildings nearby, then he can safely disregard the danger of damaging those buildings, knowing that the worst thing that could happen is he could have to pay for it. He could have to pay for that building. And what I'm suggesting to this court is...
Can you speak to the standard of review question that I asked earlier?
Yes, Your Honor, I certainly can. First of all, I agree with counsel that de novo is the proper standard of review. What I would suggest that the court should keep in mind is that there are several cases that indicate, and this I'm going to say Despain versus Avante Group, primarily was a 5th District case, tell us that the proffer is to be taken as truth. It's not a weighing of evidence scenario. It's like a motion to dismiss, but with a required proffer, and facts reasonably established are to be taken as true.
Thank you.
Excuse me. A few things I want to go to. Your Honor, I believe I understood you to say that you were well aware of the statutory elements, and so I don't want to belabor that point too much. There is something peculiar about it, and I wanted to point it out to the court if I may. When you go to the statute, it gives us a one-sentence definition. We are required to show gross negligence, of course, is the part that applies to my case, because my case is negligence. We're looking for conduct that is reckless or wanting in care that constitutes a conscious disregard or indifference to the life, safety, or rights of persons. So in this instance, I'm saying reckless or wanting in care, conscious disregard, rights of persons, because it's property rights. It's interesting, when you go into the case law that is expounded upon, primarily in the DuPont case. The DuPont case gives us this entire list of elements. Interestingly, in the DuPont case, you'll see that the court says there, we need something more than gross negligence. That case, and that's repeated a few times, that we need something more than gross negligence, that falls off of the case law after 1999, when the statute was amended and the definition of gross negligence was put in the statute. At that point in time, the statute said, you need gross negligence, and this is what gross negligence is. Interestingly enough, though, the same elements continue to be recited again and again as the elaboration on that, and so I still believe them to apply. And so, when we go to DuPont, which gives us those elements, there's a long list, and it's full of ors. It tells us it is gross or flagrant character, evincing reckless disregard of human life, or, and it continues in that fashion. I would ask the court to look at the 4th and 6th, that there is an entire want of care which would raise the presumption of a conscious indifference to consequences. Alternatively, the last one, a reckless indifference to the rights of others, which is equivalent to an intentional violation of them. Now, I don't think that we can look at the deposition testimony of the structural engineer who designed the building. He tells us there that he designed that building with the design team. The design team is a colloquial term we use. It tends to refer to the owner, the builder, the architect, the engineer, right? And he says, we designed it. We knew there was risk. There's always risk. This is something the owner had to decide whether or not to take.
And let's flesh that out a little bit. What's the purpose of the sheet pilings? I mean, generally speaking, what are they used for?
So the idea behind sheet piling, it depends. I've seen it in different circumstances. In this case, what's happening is they're moving the grade on one side. They're going to lower the property down and build some below ground stuff. And so my client's next to them. zero lot line, 100-plus-year-old building, when they start digging out, we don't want the foundation to fall out.
Right, so there was a purpose that would, behind the sheet pilings to avoid harm to the neighboring structure. Again, I'm not saying it was done correctly, but do you agree that that's the purpose of the sheet pilings as they were, originally conceived in this project?
I certainly do. I saw that a lot through the argument that we saw in the appeal, that essentially they were doing this for my client. It's interesting because, to me, I think that skips over something, which is it comes from the presupposition that they have the absolute right to build whatever they want in total disregard of what it might do to my client's property, and then they somehow do us a favor by trying to stop the soil from blowing out when they do it.
If they hadn't done anything, like if let's say that, there had been no sheet pilings, what would your claim be for damages?
In that case, it would be an intentional wrongful tort. I mean, there's no question that if you dig down beside the property, the soil will fall out.
So if they didn't put sheet piling, it would have been an intentional tort. So the real quarrel here is the manner of installation of the sheet pilings. And what do we have in the record or even in a proffer that the appellants were warned specifically against using large vibratory equipment for the installation of the sheet piling?
I can't say that I can point in the report where the engineer said don't use it for sheet piling.
And certainly that report has nothing to do with sheet piling. That sheet piling is not mentioned anywhere, correct?
No, that's
All
right.
So where do we have record support that the appellants were warned or should have known that the sheet piling construction should not have been using the general pneumatic method, but really should have been using the auger style?
So you can't drive sheet piling without an auger, so I want to make sure that's clear.
Well, the ASIP, whatever
Yes,
we want to call that.
essentially, they have to vibrate it in. There's a big crane that comes up and it grabs it, and it vibrates until
Right.
it forces it down into the ground. And the answer to that question, Judge, I would ask the court to look very carefully at the deposition testimony of Mr. Kraft. It's in the record at 162, and a few pages thereafter, it's going to be pages 18 through about 24. And what he says is a whole number of things. He's local to Pensacola. The builder is local to Pensacola. He talks about him building other things on Palafox. That whole part of Palafox Street is built on man-made material. There's riprap, ballast,
Right.
All those things. And so he tells us, we all knew that there was all this stuff under the ground, that vibration is dangerous, that there could be a problem, and if we hit something, we could crack buildings next door. In fact, after even though the report of the engineer, the geotech engineer who looked at the ground, does not talk about sheet pilings, he tells them, you can retain me to come back and do vibration monitoring for anything that you're doing here. Now, what they do is, they don't bring him back for vibration monitoring. They do, however, decide to use this vibratory equipment to drive sheet piles down. They don't use the slower alternative that he designed later after they caused the damage. They do go get a crack survey from all the buildings around so they can protect themselves from us whenever they damage our building. And so with all these things in place, I keep coming back to the idea that a builder can come in and look at something. Again, if this was just a pure accident, if he had no idea and it was some kind of freak accident, that'd be one thing. But the structural engineer was very clear that everybody appreciated this danger. And so I think that if a developer comes in, appreciates the danger, knows good and well he may damage the building next door, but if he can look at his finances and say, I'm going to make a mint here, and if I get hit, the worst thing that could happen is I have to pay the negligence damages. Now we have condoned his behavior, and still make his mint, right? Now we've condoned his behavior. Now what we've done is we've allowed him to turn it into a business transaction, and the court has closed the transaction for him. It's effectively a private eminent domain action at that point. And I would urge the court not to allow that. That can't be the law. Judges, I believe that concludes my comments. If there's any questions I can answer, I'd love to do so.
Okay. Thank you, counsel.
Thank you for your time.
I think what's been borne out in this case, Your Honors, is that this is a simple negligence case. As you noted, Madam Chief Judge, the entire purpose of these sheet piles was to try and prevent damage to Scuba's property. It's a little bit ironic that doing something that you thought was going to prevent damage may have actually caused it, but that's not enough to open the door to punitive damages. Allowing this order to stand will encourage parties to recover punitive damages for any routine negligence or property damage, and there's been no case cited to the court because none exists, finding that accidental property damage to an adjacent property during construction activities can legally support a claim for punitive damages. We don't believe that this case should be the first, and it should not provide guidance to parties to encourage them to do the same. And so for these reasons, due to the both procedural and substantive issues with this motion, proffer, and complaint, we ask that Your Honors reverse this order in its entirety.
Thank you, counsel. Thank you both. This court will stand adjourned.
All rise.